Orange Wire Selectkeep. Bill.
Bill's back in the
That's Bill
house.
coughing in the background.
He would have been here last week, but I had Colin. So,
Colin Farrell?
Cody.
Cody.
Cody?
Colin
Same
Cody.
thing.
Very close.
I was busy anyway.
How did that go, by the way?
It went really well. I thought it just died off about 1, but other than that, it was. There were people there. We're talking about the housing expo at the Jackson Crossing on Saturday,
Yes.
and I had a neighborhood meeting from. I think it was 9. I think it got over about 10:15, and 9 to 10:15 on a Saturday morning
What were there like questions?
at my neighborhood meeting. I don't think it. Well, there were 1 or 2 questions because we talked about housing.
Okay.
And how we get to improved community.
How do we do that?
We'll upload the video and I'll let you watch
Okay.
it. Many, many ways. It's not just one. There's not one silver bullet. Speaking of silver bullets, Bill found.
Not doing the same.
Oh, really?
Yeah.
No.
All right.
Okay, forget it. All right, what do you want to talk about? Purchase agreements, you said?
I suggested talking about purchase agreements.
Okay.
There's a recent case in the Michigan Court of Appeals in which the court, the dispute was over whether or not the parties who had a purchase agreement which referred to a land contract but did not have the land contract as part of the purchase agreement got into an argument as to what the terms of the land contract should be. The seller refused to approve, actually refused to even review the land contract terms that were being submitted. And the issue then became is how do you enforce a purchase agreement where there's a document referenced in the purchase agreement which doesn't exist yet. In other words,
Do you
it's
want to know
being
my
prepared
answer
after.
to that?
Then there's another Court of Appeals case in which the issue was there was a condition in the agreement or contingency in the agreement that said it was subject to the purchaser obtaining an unconditional mortgage commitment, and the purchaser ended up suing for specific performance, and the issue was whether or not the purchaser had such a quote unconditional end quote mortgage commitment. So the issue is how do you interpret language in a purchase agreement? What do you put in a purchase agreement to make certain, or to at least make as certain as possible that there won't be any future disputes as to what was being agreed upon?
Well, we attach them as addendums to the purchase agreement. So if it's going to be financed with the land contract, we actually attach the land contract to the purchase agreement.
Who's we?
Jackie and I.
Okay,
If
but
we
what
were
about
writing a
the
purchase
Association of Realtors? What does your Association of Realtors form provide in terms of reference to a
They
land
just
contract?
revised it, and I honestly I don't know. I don't teach that there, and I don't have agents that I teach to. All I worry about is what I do in my office.
And so your practice is based upon the recommendation of your lawyer that you should have the actual
Took
land
me a while to
contract,
find a good lawyer too.
the actual land contract attached to the
Yeah.
purchase, which is exactly right. In other words, when you reference a document in the purchase agreement or in a lease, in a commercial lease, so many times people don't attach the documents, or they leave it to future negotiations, and we're thinking that these are fairly standard documents, and they're not at all. Matter of fact, the Ann Arbor form used to refer to a form, land contract, which was promulgated by the Washtenaw County Bar Association, and so you either attach a copy of the document or you make reference to a specific land contract or whatever other document
Can
is
you
being
make reference
incorporated.
to one to be approved between the parties? Because I'm thinking that's what the association's form. It will put the basics like the
Yeah,
finance,
interest rate, the
interest rate,
amount, the monthly
taxes
payments,
due or
the
not
term,
due.
right.
And it used to have a late payment in there, but I know they pulled that out because our purchase agreements are geared towards the benefit of a buyer.
Well, that's an issue. I mean,
Right.
whether or not there's going to be a late payment, if you don't specify it in the purchase agreement or in the land contract, which is to be attached to the purchase agreement, there is no ability for a seller to insist upon a late payment charge.
Right, but a purchase agreement is typically, when it is written in the benefit of the buyer. Now,
It
the
depends on
seller
who's
can-
writing it. If
Well,
I'm
the
representing-
seller's not gonna write a purchase agreement, the buyer's gonna write a purchase agreement. Seller will counter, therefore the agent will have to then represent the best interest of the
It-
seller in the counter. But when a purchase agreement is written, the agent, I'm just talking about real estate
Right,
agents, are writing it.
and residential transactions, because that's not
Correct.
necessarily true in commercial
Well,
transactions.
that's, right, but most people, when they're doing a real estate transaction, 80% of them are doing residential.
Probably 90 to 95% are
All right,
residential
well, I was giving
transactions.
them-
Yeah, no, I understand that, and in the vast majority of those, the purchase agreement is prepared by the purchaser, so it's drafted presumably, although, remember, realtors, an association of realtors represents now pretty much equally sellers and buyers, so most associations of realtors forms, and county bar association forms, what those organizations try to do is come up with a balanced agreement. So you gotta understand that there are big differences between a purchaser drafted agreement, a seller drafted agreement, and then an agreement drafted by an organization which represents both. I guess the first order of business is you review the agreement to read it, understand what it says, and understand what needs to be changed in order to protect your interests.
We even attach the seller's disclosure and the lead-based pay form.
Yep, I know you do. Okay, which, there's nothing wrong with that, you know, you have to give the seller's disclosure statement to the purchaser before the purchaser signs the purchase agreement. If you don't, or before there's an agreement, and if you don't, then you've got, 72 hours, I'm trying to remember what the, 72 hours, 3 days if the seller's disclosure statement is delivered to them personally, or it's 5 days if it's mailed to them, for the purchaser to back out of the deal. But let's back up, we're getting a little bit ahead of ourselves, because you made a comment a short while ago about language that says the parties will then approve a land contract. What was that?
Review and approve contingent upon the review and approval of a land contract, or whatever the agreement, whatever they're trying to negotiate.
Do you have that in your agreement?
No,
Yeah, okay. I
no,
would hope
we
not.
attach the
Right.
land contract.
Yeah, I mean, because the instant you put into a purchase agreement that it's subject to the parties' review and approval, mutual agreement to some subsequent document, in this case, a purchase agreement, or to a land contract, what have you just done?
I created a monster.
Yeah, you've created, it's an agreement to agree, and now you really don't have an agreement.
Agreement,
because,
right.
Because now the seller or the buyer, if they want to get out of it, have a very simple way
And
to
we
do so.
we used to do a lot of land contracts, but now we don't even recommend them right now. There's the new, well, I don't know how new it is, it's a few months old, I guess.
How come?
Because the law changed where if somebody does more than 2 land contracts, I'm not even sure what it is.
The federal law, the federal law changed, and now the state law, in order to comply with it or to conform to it, provides that you can't do more than 2 land contracts,
it's
at least
2.
within a 1-year period. And so a lot of the
Without having
people-
a mortgage license law or
Without-
license.
without being registered, actually licensed, I think, under the Mortgage Brokers, Lenders, and Servicers Act. So what's happened is the individuals and entities that used to come in and buy particularly distressed homes or homes that were in foreclosure, and then turn around and flip them in a land contract sale, they can't do that anymore, because now they have to be licensed to do so as a mortgage broker. But land contracts are used now really only where the purchaser is unable to get a mortgage, because mortgage interest rates are so low. Why would I bother with a land contract if I can get a mortgage?
And most of the people who couldn't qualify because their house was foreclosed on or they had to file bankruptcy starting in '05 are,
They're through the system. They're
they're through. So you don't see the land contracts like you used to.
Right. Those are pretty much done. We just see land contracts on occasion where the seller owns the property free and clear, where it's not an outside investor coming in, but it's the actual owner of the property able to do the land contract, because they're not acting as a broker in terms of financing.
And not to mention there's a due on sale clause in
Yeah, that's
almost every mortgage that's out there now. So if you sell your house on a land contract and you have a more underlying mortgage, the lender can call it due,
Yeah, you just violated the terms of the mortgage.
right? Most people couldn't automatically refinance their house, that's why they did a land contract to begin with, probably.
Right, but again, as I said, most of those are through the system.
So let's talk about the mortgage part, because you said an unconditional mortgage, what'd
Yeah,
you
this
say?
particular this Court of Appeals decision, I just saw it last week, Court of Appeals decision in which the purchase agreement was made contingent upon the purchaser obtaining a quote unconditional end quote mortgage in order to force the purchaser to close and to force the seller to close, I guess. And so what happened was the seller refused to close, the purchaser sues for specific
Why
performance.
did the seller refuse to close?
Don't know, I don't remember from the case
And they
itself.
said they didn't provide an unconditional mortgage?
Yeah, the seller said the purchaser did not provide evidence of having an unconditional mortgage, but the underlying issue behind that was, what does a quote unconditional end quote mortgage mean?
So our purchase agreement, you say what kind of mortgage you're going for, whether it's
Conventional, FHA, whatever, that's
VA,
right.
rural development, and then you specify interest rate not to exceed,
Right?
and you're
Term
specifying.
no less than,
Yep, and then also your down payment.
okay?
But our mortgage contingency does not fall off until the day it closes.
Well, that's a different issue. That's a different issue.
But
That
that's
is-
not an unconditional mortgage, I would
No,
assume.
so those are, you're talking apples and oranges here.
Okay.
That's, because that is an issue as well, it's a sort of a pet peeve of mine, the way the Jackson form reads. But at any rate, back to unconditional. It didn't say conventional mortgage, it didn't say Fannie Mae, it didn't say FHA, it didn't say another type of mortgage, it said unconditional. So what does the term unconditional mean? It's tough to get a quote unconditional mortgage because it's going to be conditioned upon appraisal, it's going to be conditioned upon a variety of things, the
Yeah, but at some
creditworthiness
point,
of the purchaser.
those things get satisfied.
They do, but in this particular case, the Court of Appeals said that because it was quote unconditional end quote, and because there are all of these different conditions that were on the commitment which the purchaser got, it was not a quote unconditional end quote commitment.
Wow. And I wonder if that was standard language in the purchase agreement. I doubt that I'd ever imagine a realtor writing the words unconditional mortgage.
Seems a lot to me too, but that's the way this one read, the term
But they
unconditional.
added that language, or
No,
that was
I believe it was part of the
verbiage
form.
Right, okay.
Right,
That's what I would guess too.
Yeah. But that's different from the issue you raised, which is having mortgage contingency removal concurrent with the closing. That's just wrong.
Well, there are times when, there were times, and I don't know if it's still true, but the lenders will pull credit reports the day before a closing. Do you know, Jackie, if they're still doing that?
I see that.
And if somebody went out and bought new furniture and used their credit card, lo and behold, they now didn't qualify for the mortgage and we couldn't close it.
Yeah, but you couldn't close it, but you had a mortgage commitment letter that was issued well before then that said, these are the conditions and the creditworthiness, and they've pulled the creditworthiness. All you're talking about is a subsequent creditworthy check. They issued the commitment letter based upon their check of the credit of this prospective buyer 2 weeks, 3 weeks, 4 weeks before the actual closing. And so the instant that you say in the purchase agreement that the mortgage contingency does not have to be removed until closing, you tell me what the downfall of that particular language is.
Well, it's terrible language, because now you've got a seller who's more than likely moved out of their house
Right.
because possession's at closing, and
Right.
lo and behold, somebody was stupid and went and bought stuff on their credit card, the bank double checks, now they don't qualify.
Yeah, well, the purchaser's breach, if you had a mortgage contingency removal date a week or 10 days or 2 weeks before the actual closing, the seller would actually be in a better position because then the purchaser will have breached the agreement. Don't even call it stupidity, just call it their ignorance, because there is a difference, you know. Stupidity is a matter of genetics. Ignorance is a choice. Okay, as a result of their, you do know the difference, right?
I liked your reaction there,
Right.
Greg.
Yeah.
Yeah. Stupidity is innate. You're either stupid or you're not. Okay. Ignorance is by choice. You can learn something, but if you remain ignorant of it, that's your fault. So anyway, being ignorant of the fact that by now changing your credit status by going out and buying all that furniture, that would be a breach of the agreement, so long as the mortgage contingency removal date predated the closing. But where you've got the Jackson form language, where it's concurrent with closing, now they did qualify 3 weeks before, got the mortgage commitment letter, now they don't qualify the day of the closing, the purchaser is able to say, no, it's contingent upon my qualifying for the mortgage, I no longer qualify, therefore.
We should
dies.
get Ron Ellison on the show because there's a new law that's being implemented, I think, I want to say July 1,
For what?
regarding, I think the title companies have to have the documents. You no longer can call the day before and say, can I get this closing tomorrow?
Well, you do know
And you
that
can't
the HUD
change it.
statement under federal law is required to be delivered at least 24 hours
Right,
in
and
advance,
that's-
unless you waive it, and so what happens is everybody waives it because they have no choice.
Right,
But, yeah.
but that's been in effect for what,
Oh,
2 years now?
No, decades.
Oh, really, that long?
Been in force
Oh, well,
since
then
decades.
they've
Since the
re-upped it.
1970s.
No.
Yeah.
Well, there was something else that went in effect then a couple of years ago. Maybe they restated it a couple of years ago because it was such a
I
problem.
don't know, you still, I'm sure the state law is gonna allow for a waiver because there are still things that happen right up until the instant of closing, so you don't wanna have one of those last minute changes, throw a monkey wrench into your
Well, there's something coming up
closing.
and we have to read it by the first of the year, or 1st of July, I think. Jackie's over there shaking her head.
Film
Because you guys
11.
talk about things you don't know anything about.
I know.
You know what, Jackie,
No, I
she's
have no
talking
idea what
about?
she's talking about.
Okay.
Well, Ron, I'm sure
there's-
he's listening
and
and
there's
is
lots of-
shaking his head.
There's lots of legislation that's proposed that doesn't become implemented too, so.
Oh, I think this one's being implemented because they were quite adamant about it at the general membership meeting.
They being, who's
The board, the association, Ron Ellison.
Okay, all right, well, we'll find out what that is. But at any rate, yeah, I always, in my agreements, all contingencies have to be removed well in advance of the closing, because we don't want to have to wait, we don't want to get down to a closing and find out those contingencies aren't satisfied. Right?
Yeah.
Right. What else you want? You're
Um,
looking
You're
at
out
me
of time.
expectant.
I'm out of time. We'll talk about properties for sale.
Go for it.
Okay. We have, it's gonna be 70 today, right? And tomorrow's supposed to be a beautiful day, so
Yeah.
time to buy your house that's close to the lake, I would say.
Sure, why not?
4654 Virginia Court, a cream puff. I mean, this house has got high-end, everything in it, 139.9, 1 bedroom, 1 bath, a little over 800 square feet with a deck off the back, and it's just steps away from Clark Lake. We have vacant land, 30 acres with 2 acres of commercial in the front on Spring Arbor Road, 6190, 6200 Spring Arbor Road. That's down to 249. There is a big pole barn on that property. There's a house that probably should be bulldozed down on that one. Western Schools, 3128 Lori Drive, 124.9, 3 bedrooms, 1.5 baths, just under 1,300 square feet. That's in a really nice little neighborhood. Then there's 1414 West Washington. This is a project, but it's a project that would be worth the elbow grease. 89.9, that's actually a 5-bedroom house with 2.5 baths, just under 2,600 square feet. Mulligan Drive, we've got a couple of lots that go together out there for sale for $30,000. That overlooks the golf course at the country club. And everything else 912 Dunnacourt, 53.9, that's in Blackman Township, cute 2-bedroom, 1 bath, just under 800 square feet, and that's a short sale. So if you want to get your, we're also, that placemaking project we're working on downtown. The website is up. You can go and volunteer hours, vote on the project you like at activatejackson.com. You have until the 24th of April. And then we'll be implementing those projects May 9th. And you can call me to get your house on the market or to show your property at 780-3800 or go to thinkingrealestate.com.